Two separate Republican-appointed federal judges have ruled against Donald Trump back-to-back on Friday night, related to his efforts to blacklist major law firms in America that he doesn't like, or represented people he doesn't like, or represented Robert Mueller back in the day, or worked on the Mueller special counsel investigation against Donald Trump. You know, Donald Trump's retribution campaign. Well, you either obey or you fight. You either bend over like my old law firm, Skadden Arps, and offer to pay $100 million to Donald Trump in tribute to go away, or Paul Weiss and pay $40 million and completely scuttle and sacrifice your pro bono program, your hiring program, who you are as a law firm, or you fight. And the law firms that are fighting, I know well, they're well-known litigation in powerhouses in many respects. One firm, Jenner and Block, represented by another firm named Coie. They should get credit as well for effectively getting to the crosshairs of Donald Trump. And in the other case, that case is in front of Judge Bates. And in the other case, in front of Judge Leon, Wilmer Hale, represented by a right-wing former person in the in the Bush administration, who was Solicitor General Paul Clement and his small boutique firm. He's representing, if you can believe it, Wilmer Hale. They had hearings on their temporary restraining orders to stop, under violations of the First Amendment, this retaliation campaign, and they walked out the door with two very strong temporary restraining orders, putting these law firms back into business against the Trump administration. I'm Michael Popok on Legal AF. I'm going to cover it right now. There is a secret list, apparently, of about 14 different law firms that Donald Trump wants to, his naughty list that he wants to go after. He started with Perkins Coie. Perkins Coie, he didn't like them because a couple of the people there were involved with the Steele dossier and the Mueller investigation. This is all Mueller investigation payback time. So he went after Perkins Coie, put them on the blacklist, barred them from federal offices, barred them from doing business with the government, barred them from representing clients who had business before the government, effectively trying to put them out of business. And there are 275 employees out in Washington state. They filed a lawsuit. It was assigned to Beryl Howell, the former chief judge in D.C. And about 2 weeks ago, she entered a temporary restraining order, finding it to be an abuse of power in violation of the First Amendment, and put Donald Trump back in his chair. Now, interestingly enough, the lawyers that represented Wilmer Hale, this well-known firm out of D.C. that does a lot of white-collar criminal defense, a lot of political representation, a lot of representing clients before federal agencies. That's their stock and trade. They and their lawyer, Paul Clement, tried something very smart, but it didn't work. They tried to get their case assigned to Beryl Howell, who had already ruled in favor of Perkins Coie, saying it was a related case. In other words, it's related because all these executive orders are effectively the same. But Beryl Howell, who got the case filed directly to her, backed out and said, nice try, but I see the issues are similar, but the facts are different, the law firms are different, the parties are different, and you're going to have to go through random assignment. She kicked it back to random assignment, and that case got assigned to Judge Leon, who is a Reagan or Bush appointee, certainly a Republican appointee. That's how that case ended up there. But with strange bedfellows, Paul Clement, who was Solicitor General under Bush, he was the guy in favor of waterboarding, of all things, on the wrong side of gay marriage. But, you know, he's stepping up for law firms right now. He's also, if you remember, the special counsel or amicus lawyer that was hired by Judge Ho in New York's Southern District of New York federal case to decide whether he was going to dismiss the Eric Adams, the mayor of New York City's indictment, with or without prejudice. He wanted guidance. We still haven't gotten that ruling, but he turned, even though he was a Democrat and he worked for the ACLU before becoming a judge, he turned to Paul Clement. So he's a well-known guy. He's a real, he's got a brand. On the other side, you have Judge Bates, senior status Judge Bates. He's got the case involving Jenner and Block. All the cases are basically the same. Whether I say Perkins Coie or Jenner Block or Wilmer Hale, it's all basically the same. Executive order or threatened executive order by Donald Trump to blacklist the firm, to bar them from federal property, federal premises. These people can't operate. If they can't represent clients and go into all the federal agencies, Securities and Exchange Commission, Federal Trade Commission, Internal Revenue Service, if they can't appear before the Department of Justice or any of their offices or the U.S. Attorney's offices, they're out of business. Jenner and Block, Wilmer Hale said, like 40% of their revenue comes from doing something with the government, the federal government. $500 million. They're out of business. And that's what scared the crap out of firms like my old firm, Skadden Arps, where I used to proudly say I used to work and I cut my teeth, and now no longer, because they decided, talk about daddy, don't hurt me again. Paul Weiss settles for $40 million after they get nailed with an executive order, where we'll redo our pro bono program. We'll represent all Trump principles. Whatever you want us to do, we'll get rid of our DEI. We'll fire all our black people. Why not? Just don't hurt us any longer. And we attacked Paul Weiss, and we said, that's not your role. And then Skadden watched it and said, well, that didn't go so bad. And a couple of days of bad press, but they're still around to talk about it. We'll pay $100 million. A bigger firm with more revenue will pay $100 million. We'll talk about that in another hot take that I got running right now. So you're either in that camp where you obey and you violate your oath to be a lawyer, or you fight like the firms representing the firms and the firms themselves that are fighting against Donald Trump. Shout out to Coie, a major law firm that's representing Jenner and Block, putting themselves in the crosshairs. Shout out to Paul Clement. I never thought I'd say that, because at least in this area, he's on the right side of the angels. So we got two orders that came out back to back in losses for Donald Trump. At least I forget. We have the first one concerning Jenner and Block. There, the judge got frustrated with the lawyer representing the Department of Justice. He said, well, wait a minute. Are they banned and barred from going to federal offices and buildings and meeting with federal officials, or are they not? Well, we're still developing the guidelines. He said, I think you'd come into my courtroom on a temporary restraining order against an executive order and fully understand the impact of your executive order. Would you not? So here's what the judge entered. I'll read you from his order granting entirety, the temporary restraining order in favor of Jenner and Block. Shout out to Coie again, a firm, for having brought this case. The motion is granted. The defendants, that's, the U.S. Department of Justice and everybody in the government, are enjoined from implementing or enforcing Section 3 and 5 of the President's March 25th, 2025 executive order entitled Addressing Risks from Jenner and Block. See, that's their lie. That's their excuse. It's national security. There's security risks with Jenner and Block. 4 years ago, they used to have a guy that worked there that used to work on the Mueller investigation against Trump. So there's a security risk. And Judge Bates said, that's you're doing lip service. That's not a real thing. And even if you thought that was a real thing, this executive order goes too far. You want to revoke their security clearances and do it under a hearing with due process because they're due process rights? Go ahead. But otherwise, blocking them, banning them from doing work with the government, banning their clients from doing work with the government, that's way overkill. Enjoined. And I want a status report on the March 31st, on Monday at 12 o'clock, about how this order has been complied with. And all the other departments too. Now I flip over, because it happened the same day, same courthouse, two different courtrooms, with Judge Leon, with Wilmer Hale, represented by that Paul Clement fellow I described. And here's what he said. He wrote a longer opinion, and I thought I just knocked over Ruth Bader Ginsburg, or she's turning in her grave, one of the two. So here is the memorandum order that he entered. He said, I find that there's a substantial likelihood of success on the merits. In order to, quick TRO lesson, in order to get a temporary restraining order, if you're the party moving for it, you got to prove four elements. You got to prove a likelihood of success on the merits, meaning it is likely, if you look under the hood and peer down the road at trial, you're going to be the winner based on your constitutional or jurisprudence or legal analysis. That's one. Second is irreparable harm. You're going to be put out of business if I don't issue this injunction effectively, or people are going to die. Something like that. Inadequate remedy of law, similar. Money doesn't satisfy. Money won't fix the problem. That's that element. Public interest is in your favor, third element. And fourth element is balance of equities. Balance of equities tips in your favor, and public interest. Okay, those are your four elements. Now, here's what the judge said. Said to the Jenner and Wilmer Hale, which is also known as Wilmer, Cutler, Pickering, Hale, and Dorr. It's a merger. A lot of these law firms merged. There was a firm in Boston called Hale and Dorr. There was a firm in Washington called Wilmer, Cutler. So they put them together, and it's known as Wilmer Hale. I'll call it Wilmer Hale. Okay, I used to know it as Wilmer. Most people in the Washington regulatory area know the firm as Wilmer or Wilmer Hale. Okay, so here's what the judge said. He goes right to the First Amendment on page 2 of his order. As to the first factor, the firm has shown a likelihood of success in the merits of its First Amendment claims as to sections 3 and 5 of the executive order. Undisputably, the First Amendment prohibits government officials from subjecting individuals to retaliatory actions after the fact for having engaged in protected speech. This prohibition includes retaliatory actions based on perceived viewpoint. The retaliatory nature of the executive order at issue here is clear from its face, not only from section 1, but also from the fact sheet published the same day. Indeed, the executive order requires government contracting agencies to disclose, review, and terminate all contracts with the plaintiff, the law firm, and restricts Wilmer Hale employees from access to federal officials, buildings, and employment. That is section 5. Blacklist, barred, persona non gratis. There is no doubt this retaliatory action chills speech and legal advocacy, or that it qualifies as a constitutional harm. They went over on page 3 about how impactful this would be. Here's the irreparable harm prong. Indeed, enforcing Section 3, the government contracts provision, would threaten almost 1/3 of the firm's revenue. They filed a declaration, which I'm sure they hated to do with all their competitors who are just chomping at the bit to get their work. But they had to say that at least 21 of the firm's 25 largest clients in 2024 had contracts with the federal agencies. 21 of 25 have contracts with the federal government. That's Wilmer. Wilmer is known as like the law firm's law firm. It's where you go. It's one of the 2 or 3 firms you go to if you got a problem with the government or you want to do business with the government, because they know it. There are people who used to work there, revolving door. They got judges that are, I think Judge Nichols came out of Wilmer. You know, there's like this whole ecosystem in Washington that they're a part of. These 21 clients that the affidavit continued, the judge cited, accounted for more than 30% of the firm's revenue. That firm is very highly concentrated. Of the 21 largest clients represent 30% of the firm revenue. It's not very that balanced, but that's what happens when you have a firm like this, which represents nearly $500 million to the law firm. Now you see why Skadden tried to settle for $100 million, right? Because they just calculated they don't need this problem for the next 3 years. And plaintiff is also currently handling over 100 open government contracting matters involving federal agencies. So they have 100 matters right now for clients in front of federal agencies. Losing these clients would be a devastating blow to plaintiff, the judge ruled, threatening their very existence. This says nothing of the potential clients who may not even consider hiring plaintiff because of their concerns about losing government contracts, that they're so intertwined with the federal government. And he then entered it. He wants a joint status report on Monday as well at 4:00. So you've got, they don't coordinate, as you can tell. Judge Bates wants the government at 12:00 on Monday, and Leon gave them till 4:00 to do their joint status report about what is happening. This is how the world is divided. Right? You're either fighting or you're obeying. You're either giving Trump $140 million worth of tribute by Skadden and Paul Weiss, which will only embolden him to seek quote unquote settlements, i.e. extortion, from other law firms, or you fight and you win in courts. Donald Trump is 0 for 3 when he gets to a federal judge. Beryl Howell, temporary restraining order to effectively blacklist Perkins Coie. Judge Bates, temporary restraining order to fire Jenner and Block or blacklist them. Judge Leon, temporary restraining order on Wilmer in favor of Wilmer Hale. They're 3-0. They're batting 1,000. Why But you know, these other firms that have been singed before with other public settlements and other attacks, they don't want to risk it. Remember, I'll leave you on this. Regardless of what type of law you practice, commercial, transactional, dirt, intellectual property, regulatory, IP, everything about the internet, nothing about the internet, family law, divorce law, personal injury law, litigation, commercial litigation, whatever it is, transactional or litigation. That's how the world usually divides. Corporate regulatory. Okay. You took an oath. This is a profession. If you just wanted to practice business, then you shouldn't have become a lawyer. You should have went to MBA school or right to Wall Street. You want to be a trader. You want to be a broker. You want to be an iBanker. You want to be a hedge fund guy or person. You want to be a startup tech bro, then go do it. But when you took the oath, regardless of your practice area, you are a lawyer. You have a bar license. That allows you to practice. you, pardon me, agreed to uphold the Constitution, the rule of law, comply with the rules of professional ethics. I know that non-litigator trial lawyers don't care about that, but I do. I'll continue to follow it right here on Legal AF, the YouTube channel. Until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.